on today's episode of Retrial Podcast.
There's this this story, I guess, that you talk about in, again, your book, Slough of History's Boot Soles. Slough of History's Boot Soles? Did I say Slough? Slough of History's Boot Soles?
Slough, yeah. I confess it's probably the worst title ever given to a
the book is amazing, but the title, man, we got
it stinks.
Welcome to Retrial Podcast. I'm Judge Gerald Parker, along with friend, colleague, David Greer. Dave, what do you think about this jersey, man?
I like that jersey. I learned how to play football with one of those guys from the Triangles.
The Dayton Who are the Dayton Triangles, for folks who don't know?
Oh, the first great NFL team. First NFL game played right here in Dayton, Ohio.
That's awesome. Well, we're excited to have everyone here for Retrial Podcast. This is a podcast where we decode legal history here in Dayton. We're going to be talking about, I guess you would consider one of the best attorneys ever to come through Dayton, Ohio, John McMahon. I said McMahon on episode 2. Is it McMahon or McMahon?
Well, he's not around anymore to complain, but McMahon, I think, is the way he...
McMahon? Let's do John McMahon. 69 years of active practice. In 1852 is when he started. You weren't around there.
Not until a couple of years later. Actually, he lived from 1833 to 1923. 90 years. That's a long time.
That's amazing. So we're going to decode some legal history, talk about John McMahon, and the time period is very special because it kind of makes what Gem City is and what Dayton is, because I got to run through some of these things because there's so much amazing things that happen. We've got, of course, technology and industrialism. We've got flight, of course, for the Wright Brothers. We've got NCR, John Patterson, Dayton Power Light Company, moving James Cox, purchased Cox Media. Everyone has seen Cox Media somewhere, and Dayton Daily News, of course. Paul Lawrence Dunbar around that time, and of course John McMahon, who's got his hands in all of this stuff. Tell us about this time period, that really sets Dayton apart.
Yeah, we were the industrial, inventive center of the state of Ohio, certainly, if not the world.
Yeah.
I mean, the self-starter, the airplane, the folding ladder, ethyl gasoline, and we've still been doing it, we got all the way to the most important invention in modern history, the tear-off top of the beer can.
Oh, yeah.
That was Ernie Fraze right here in Dayton.
Wow.
We had more patent lawyers in Dayton than any other city in the state. I don't know why it was, but this was a hot place for all that stuff. And legally as well, McMahon comes into the bar just a couple of years before the entire judicial code of Ohio and code pleading and everything got rewritten with the Constitution of 1851.
Right.
So here he is, a young guy, superstar at an early age, long career, and a lot of interesting stuff.
Yeah, and we'll talk a little bit about 1913, of course, the Dayton flood that changed the game with a lot of different things. But why would you consider him the greatest lawyer in Dayton's history?
Simply because he was. I mean, he started out as a prodigy, trying cases and winning cases against all comers, the best lawyers in the state and the country. 1874, we'll talk about his trip to Congress, where he proves himself. Joe Cannon, who was the Speaker of the House for 1,000,000 years, always said that he'd seen a lot of lawyers in the House of Representatives of the United States, but he never saw one as good as John McMahon.
Interesting.
That's quite a chunk of praise.
Right. So, I guess the Miami Conservancy District. That's why is that so important? I mean, after this flood, and you talk a little bit about that in one of your books, and I guess it wasn't really met with that much embrace at the time when John McMahon, I did it again. It's
That's
McMahon.
all right.
McMahon, he's not here to get mad, like you said. You can't tweet about it or something. He was influential in how not just Dayton addressed the flood, but other states other jurisdictions, Tennessee as well, address their issues as well.
Oh, it took 20 years for the others to figure it out.
Right.
I guess the greatest thing he did for Dayton is make it possible that all of us who live here don't have to have bailing cans in our living rooms. The Indians were smart enough never to have a village here at the confluence of these 5 rivers, because every spring it flooded. And indeed, Dayton experienced floods every spring of minor quantities until we had 1913. And now we got one of the best underground aquifers in the United States of America, and we don't have any floods. And that's in part a grand feat of engineering, but it's also a grand feat of legal work. And people don't think of it as a legal thing. But when you talk about creating something that had never been done before, of bringing together different political entities to solve an environmental problem that affected all of them, a river that had to flow through all these different places.
Did you say bringing political enemies together to solve an environmental problem? I don't think I've ever heard or seen that happen, nor will I. It seems like I never will see that happen.
Well, it's a very complicated thing to do.
And obviously.
After that flood, McMahon gave up his practice of law for months and spent all that time studying how he could create an entity that would permit this structure of dams to control the flow of all these rivers, and have it done in a way so that the cost of it could be equitably spread out among the communities that were benefited from it, and then have a mechanism in there so if there's a dispute over somebody being charged too much, it could be resolved. So he wrote this whole act without any precedent. It was passed by the legislature in Ohio, and then it was attacked on all sides, on every constitutional ground you could think of: equal protection, due process, home rule, state constitutions, federal constitutions, and there was no precedent for it.
Right.
In fact,
except for a flood.
Except for a flood.
A flood that pretty much devastated the entire community. It seems like a pretty good precedent. But
flood that saved the NCR, turned it into a boat building operation instead of a bunch of people convicted under the Antitrust Act in Cincinnati in February of 1913. And made heroes out of John Patterson and all those guys. So between the engineering and how the dams were created and the crisis in the community that it was a response to, when McMahon, old Colonel Deeds, who regarded McMahon as kind of not only a friend but a father figure to him, said that McMahon had told him, when I die, if it weren't for the fact that all my family is buried in the graveyard here in Dayton, Ohio, I'd really like to have my body buried underneath one of those dams on the river that we created.
Wow.
So one of the most beautiful renditions at his memorial service when he died in 1923 was given by the man who had been Chief Justice of the Ohio Supreme Court when McMahon had to go to that court and argue the constitutionality of the Miami Conservancy District Act. And as we said, it was attacked on all sides by all sorts of other communities. And he described McMahon as this old man in his 80s, speaking for an hour without any notes at all, just telling the story of the logic of this piece of legislation that had not been done before, so there were no precedents to cite. All you could do was rely on logic and need and spin it all together. And there's this old man talking for an hour, and it was just a remarkable snapshot that stayed in the Chief Justice's mind.
Well, I want to talk about him as a litigator. There's this this story, I guess, that you talk about in, again, your book, Slough of History's Boot Soles. Slough of History's Boot Soles? Did I say Slough? slough of history?
Slough, yeah. I confess it's probably the worst title ever given to a
the book is amazing, but the title, man, we got to do
stinks.
something.
But it came from Walt Whitman, after all. He talks about how the real understanding of what life is all about is the tires of carts and the people in the streets and the mud that you have to walk through and get on your boots.
I got it.
So that's where the rubber meets the road, as you would now say.
Yeah. You talk about he was so revered. John McMahon was so revered that he appears in front of this, I guess, relatively new and young judge, and that kind of appealed a little bit to me. And the judge had so much respect for Mr. McMahon, and he asked him, what would you do if you're in my shoes, trying to make a decision on a particular part in the case. And the neophyte judge, as you say, was recognized by John McMahon. He said, young man, rather than calling him a judge, he says, he's reported to say, young man, my client retained me to do the best job that I could do for him with the facts that he gave me. He said, this I've already done. My responsibility has stopped. Now it's yours. And he said that to the judge, and I'm sure the young judge was like, oh, I guess it's time for me to do my job. So he's very confident, and he pretty much put the neophyte judge in his place.
Yeah, and
you would never do that to a neophyte judge, would you?
Well, I don't gain any respect. Here, I'm 85 after all, and I don't get any respect. Don't know that I deserve any, but Mr. McMahon did. So it's kind of refreshing to see somebody get a little nod like that.
And he built that respect, I presume.
And he started out his career winning case after case against all, met and fought every foe the arena had to offer. He got lucky as a young man, too. There's a lot of luck goes into everything in life, including the practice of law. And if you get a lot of good cases when you're young, then you got a chance to build up a reputation that takes a long time to build a reputation, and fortunately it takes a long time to lose it, too.
Right.
But at any rate, he started out with his uncle, who was Clement Vallandigham, the copperhead in Lincoln's Congress. And Vallandigham went on to Congress, leaving McMahon back at the office to take care of all the work. So McMahon was trying all the cases that had been brought into his highly respected senior partner, who was also his uncle. So he got a flying start in the practice, and he got into the practice just as at the time that the great commercial development of the United States was going on, and going on big time in this particular area. All these inventions and all these people and inventors and skilled people. And skilled or unskilled, comes time in your life, you need a lawyer. And so he was the guy that drew them all and represented them all and fought all the battles for them. And apparently was a lovely man to deal with, just as a human being to talk to.
So his relationship with some of these pioneers, Governor Cox, Colonel Edward Deed, the Wright Brothers, John Patterson, Governor Cox, interesting figure. Of course, the Dayton Daily News, and then on from there as a conglomerate with Cox Media. What kind of interactions between Governor Cox and John McMahon?
Well, of those people that you mentioned, I had dealings with all of them. Mm-hmm. The two that he was really close to were Governor Cox and Colonel Deeds. And he was older than either one of them. Okay. So they kind of looked at him as their mentor, as a father, and also as their close friend. I mean, late in life, I think he had lunch every day with Governor Cox. And I think on the weekends, always had at least one dinner a week with Deeds. And there's just a wonderful relationship between them. They relied on him for guidance and legal advice. And everybody, no matter how high you rise in your trade or in society, nobody does it alone.
Yeah, I feel like everybody, talks poorly about lawyers until they need one, right?
Yeah, we're nobody's friend until we represent you. Then sometimes we're the only friend you have.
Absolutely, no.
There's on that thing, as far as Colonel Deeds is concerned, all those guys got together in World War One, and they had the Wright Patterson airplane company, and we're building airplanes and selling them to the government. And like everybody in wartime, they're accused of making too many profits, and so there was a Senate investigation. Colonel Deeds gets called down to Washington. There's all this bad publicity, and Charles Evans Hughes is the senator who gives him a big cross-examination about how they ran this company and so forth. He's in one of those positions where it looked like all your friends have fallen away, when nobody knows you when you're down and out, and when you got money, why, here they all come back again. So there's the story of Deeds coming back from that tough trip to Washington and coming down the Union Station. We had a beautiful train station in downtown Dayton, right off 6th Street. And landing there and walking down the tracks and out the gate, and there's nobody there except old John McMahon, his friend and lawyer.
He's right there.
And they shake hands and go back to whatever they did.
Right. So, one of the things that John McMahon is really known for, particularly as it pertains to the Dayton Bar and the bar associations across the state, is creating the bar associations and being a part of the Ohio State Bar Association, and from there on. For most folks, how would you describe a bar? Because he actually described what he thought the bar should be. But what was your thoughts about? What are your thoughts about him and his influence with respect to bar associations across the state and country?
Well, of course, we can have nothing but good things to say about them, because without the Dayton Bar Association, we wouldn't be here having this conversation.
Shout out to the Dayton Bar Association, DBA, all the way.
We're very blessed in the bar association that we have here in Dayton, as well as in the lawyers that we have here who know how to fight with each other but get along together as professional people.
That's the truth.
And we've now got in Jennifer Ochi as fine a executive as I think anybody.
Shout out to Jennifer. Shout out
Jennifer
Ochi. How are you?
A wonderful executive.
Yeah.
But the whole purpose of a bar association is to benefit not lawyers particularly, but to benefit the society that they serve, to make sure that there are standards that lawyers have to live up to practice their profession, to make sure that there is some rules and guidance as to how you become a lawyer, and whether you have the moral and personal qualifications as well as the intellectual qualifications to do that kind of work, so that we don't turn loose a bunch of mad dogs on society that are just there to steal money from potential clients.
Yeah, they think that anyway, don't they?
Well, yeah, and then, there's no net that will keep all fish in.
Yeah.
So there's going to be some that get loose.
So he was president of the Ohio State Bar Association in 1887, and then in 1868 was one of the incorporators of the Dayton Bar Association. One of the things I found fascinating when he wrote about in your book, the purpose of bar associations, which most folks outside of the legal community do not know, but his purpose regarding the remedies that he wanted to make in the profession, make the laws of the state more clear and understandable. I thought that was fascinating. Offer salaries for judges that would bring to the bench energies and abilities that were otherwise surrendered to corporations and other clients. I really like that one. Raise the standards of admission to the bar by making the entrance examination more difficult. Establishing a probationary period of new lawyers. And education of lawyers by more thorough and supplementing the state bar examination. Just trying to make lawyers grow and become better practitioners. And he was on the forefront of doing all that.
That he was, and of all those things that you just listed that he wished would be accomplished, I still wish that some of them would be accomplished a little better than they are, especially that thing about laws being clear and understandable.
That's the very first one. I was still stuck on offering salaries for judges, but still. Well, yeah, let's talk about that, because explaining the law to clients, having been in private practice and having been a former prosecutor, and then having you as well, who's tried everything under the sun, sometimes what we're doing in court may not make as much sense as we'd like it to, right?
Yeah, that's true. We kind of touched on that in some of the other
That's right.
discussions that we had earlier today in these earlier episodes.
Yeah.
But trying to turn the law into common sense or turn common sense into law
Right.
is a trick.
Yeah.
And no matter what is written, there's ambiguities that are going to be argued over as to what was really meant, what was the intent of the legislature, and who cares, and what's the right thing to do.
Yeah.
And it's funny, over 60 years of practice, you encountered judges at every end of the spectrum. Those who parse each word carefully and work their way to a conclusion which may take them out or here or there or anywhere, and then come up with a resolution. And you've got other judges who forget the books completely, and I go by what my gut tells me is the right thing to do,
Right.
and I'll do the right thing, and then I'll rationalize it.
And the third way is to have an awesome staff attorney, which I have, and she does a great job. So you can do that as well.
And that's a good thing up to a certain point. And I agree that, and we've got the fortune to have staff attorneys for judges that are helpful. They tend to be young people, and they tend not to have the experience
Practical
on the ground that it sometimes takes to make the kind of judgments that judges have to make in interpreting the law.
Oftentimes, the more difficult decisions are the ones that I want to be involved in, because that's how you learn and how you grow.
Yeah.
And I feel like that's the best part about being a judge is you don't know everything, so you get to find it out. You know what you know, and then there are certain parts of it that you don't know, and you can look at it and grow yourself. So and learn from the lawyers and not pretend like you know it all.
Yeah, it's ever changing, and nobody has their arms around the whole thing.
Right.
And the criminal law nowadays, it used to be so simple, and now it's so complicated.
Yeah, it is.
I mean, DUI or too much in your alcohol or whatever in your body when something goes wrong.
Yeah.
That used to be a pretty simple thing.
That
now
section
it's
is
very
thick.
complicated.
That section is very, very thick. You talked a little bit about, and we talked before about the unethical price fixing of fee schedules, how much that changed over time, and what was being done then, and of course what we do now. You want to talk a little bit about that?
Yeah, if you look back in the olden days, lawyers they considered themselves like a craft in medieval England. If it's bricklayers or whatever, they're doing the same craft together, and so they ought to protect themselves as well as protect the people they're there to protect. So for years and years, there were these minimum fee schedules that the Bar Association had that said, in order to ensure that everybody gets competent representation, we don't want anybody just doing stuff for nothing. So we're going to have a minimum fee schedule. We've got some examples of them. Hopefully we can show them here. That there's one in 1904 that's John McMahon's autograph is on it, as well as the autographs of every lawyer in Dayton. And what it is, essentially an agreement, is you won't charge less than a certain amount for certain kind of things. And it's got a laundry list of all those things. The one that sticks in everybody's mind is, okay, how much was the minimum fee for representing somebody in a first-degree murder case? $300 in 1904. Now we've got Mr. Epstein's girlfriend who gets 20 years for something that has no capital aspect to it.
Right.
Who turns around and is suing her lawyers, or her lawyers are suing her, I guess, for $800,000 or $900,000 of legal fees.
Yeah.
One of the
a lot more disputes over legal fees that come later on.
Oh, yeah, and you wonder if we haven't simply priced ourselves out of business.
Right. Yeah.
Who can come up with that kind of money to defend themselves if you had to? $300? Yeah, you could probably do that.
What about the business of being a lawyer and advertising, then and a little bit into now?
Well, it's just the other side of the coin. Of course, the United States Supreme Court ultimately held that minimum fee schedules violated the antitrust laws, so that you don't have those anymore. If you want to work for nothing, you're perfectly welcome to do so.
Right.
The other side of it was advertising. In the old days, and indeed during the first half of my years of practice, the only unethical things that lawyers could do, aside from stealing money from clients or committing a crime, was to advertise their services. We had a lawyer who lost his license because he sent letters to people who had workers' compensation claims saying, "I'd like to represent you, would you mind?"
I could never see that happening.
And I mean, now that table is turned totally upside down,
Right.
so that if you have a fender bender accident, you can count on your mailbox being filled with all sorts of.
That police report's ready, and they get it.
We're the best. Funniest one of those that I can remember is we had a lawyer in town who wanted to get a lot of good plaintiffs' work and spent $10,000 on a billboard. And there's this picture on the billboard, and if you have an accident, call me. Then he forgot to put his telephone number on the billboard.
Usually it's just one number now. It's like 111. Call 111 1111. That's all you got to do.
And there's nothing wrong with that because we never effectively developed a way of steering people to client or to the lawyers.
Yeah.
It was always word of mouth, and in a small community, word of mouth works.
Right.
Doesn't always work in a huge community like we have now evolved ourselves into. And the Bar Association tried to have a referral service that would solve the problem, but it didn't solve the problem because how can you run a bar association that's composed of this many people?
Right.
And if you want to get the client to the right ones, you got this many to refer them to. So the bar has that conflict of interest problem that they can't cope with it. Right. So we're left with a lot of advertising by lawyers, which is all right. It doesn't assure you that what you see is what you get,
Right.
and it does give those who like to sue lawyers a wonderful playground to work with. I mean, here you put out this stuff that said you were the best, and you've done this, and you've done this, and you've done this, and you've done this. Now, is it true that you've done this? Well, maybe not. Is it true that you didn't? No, maybe not. Yeah. So you set yourself up for some shots.
Well, what's interesting is John McMahon was concerned that the public faith in the profession has been considerably shaken, even in intelligent circles. And there remains a concern from which we are unlikely to become free in a complex society with conflicting interests and monetary allures. You mentioned that in your book as well. And he had those concerns, well,
if we went on out to Woodland Cemetery and knocked on the tombstone and were able to summon up his ghost, I expect he'd still be a little upset.
Not too much has changed, I would think. Yeah.
Things change, but they remain the same in some respects.
Yeah. Well, what did you find the most fascinating about John McMahon in your research? And we're going to get to the some of the present day illustrations that took place that he was involved in until where we are now. But what fascinated you, and what makes you think that he was the greatest attorney in Dayton history? Obviously, but what we've talked about has been amazing. But was there something about him that you say, if you needed to have one of these traits of his, that would qualify you as being underneath that orbit there?
Well, they say he was a very calm and thoughtful man. He wrote the briefest of briefs. He gave the shortest of statements,
right.
But that everything that he said or wrote counted.
Right.
And those are skills that are hard to have. I mean, everybody talks too much, and
right.
including myself, and writes too much or doesn't focus. He was a hardworking person who had a great sense of focus on whatever problem came before him. We talked about him shutting down his office to try to create this Miami Conservancy District, which had never been done before, was never done again until the Roosevelt administration in the 30s did the Tennessee Valley Authority, which was the same concept kind of stolen from John McMahon.
Yeah.
So those things are significant. He was loyal to his clients. I mean, his Deeds and Cox and those people treated him as a father figure. as somebody that they truly relied on for advice and guidance. And how do you get there? He was thought of by the whole bar that way. You know, they had these composite pictures every 10 years or so that had little snapshots of all of the lawyers in the community at the time. It stopped in 1962 because you could only put so many angels on the head of a pen. You just couldn't fit them all into a composite picture. But in a number of those composites, he's not a judge. He's not the mayor of the city, but he's the one that's in the middle, and he pops right out at you because he was revered by and respected by everybody he ever met.
Right. There was a quote: "Lack of mistakes comes from experience, and experience is the product of lots of mistakes." I loved that quote. I think that is something that everyone should remember, especially as lawyers who either have or have not been in the arena or the trial arena, who are afraid about slipping up, making a mistake in front of a judge. It seems like John McMahon was looking forward to making mistakes because he knew he was going to learn from them.
We had a real estate operation here in town that picked that thing up from him and then turned it around, made it a little too strong. It was on the letterheads they sent out had on it, "We never make mistakes." The reason we never make mistakes is because we used to make a lot of mistakes. but that's true. You learn from those things.
So I want to shift gears a little bit into present day. And actually, I want to start with the Hayes-Tilden dispute of 1876, considered probably one of the, if not the most contentious elections in history. Do you agree with that?
Oh, absolutely. It was the Bush versus Gore of its day. It was, I think, a great turning point in American history. When President Grant came back from his tour around the world, after he finished his 2 terms as President of the United States, somebody asked him, looking back on it, what things would you have done different during your presidency if you had, known what you know now? And his answer was, I would have left the military in the South. Because what happened in the Hayes-Tilden dispute, and I don't think it made too much difference who won, who lost.
No, correct.
Because Tilden was no friend to the black man any more than Hayes was.
For those who don't know, we've got Hayes, Rutherford B. Hayes, who obviously one of our presidents, from Warren, Ohio, right?
Yeah.
And then Sam Tilden, runoff, and believe it or not, Tilden wins the popular vote, right?
He does indeed.
My gosh,
but then you got that electoral college.
Are we doing this again?
Yeah.
We're not going to do this again. Are you serious?
Yeah, and it goes to the electoral college, and a deal is cut. And the deal is that if the electoral college will switch their votes from Louisiana to Rutherford B. Hayes, the Republican candidate, then the military will be pulled out of the South. That's what happened.
So this time the Republicans stole the White House. I guess you could say that.
Yeah, and as far as the outcome is concerned, maybe in race relationships it wouldn't have made a lot of difference. But Hayes was the party of Lincoln, the Republican Party. And it seemed to me to make that deal was unfortunate.
Yeah.
At the time, McMahon served 2 terms in Congress from 1874 to 1878, I guess it was. And he was one of the dissenters in that Hayes-Tilden dispute, and he has this wonderful scroll that's signed by all the dissenters saying, "When fraud is law, filibustering is patriotism." And the reason I feel so badly about that election of 1867 is that I think it accelerated the Jim Crow laws. It's right after that all the Jim Crow laws come into being. And if you're walking the streets and you don't have a job, wham, you're thrown in jail and you're given a fine. Well, I can't pay the fine. He said, well, that's all right. You can work it off. Right. We got all these wonderful mines that you can work in. We got these people that need help on picking cotton. We'll put you right back where you were in the good old days.
The good old days, right.
The good old days. Remember the good old days?
Right.
And So we went through all of that, and we have people being lynched all over the place. All these terrible race riots that go on, and that went on for 100 years before we really got a civil rights movement with any traction in this country. So I don't know that you can put all that blame on Rutherford B. Hayes, but looking back on it, when you push people, they push back. And you had all these people that fought for the Confederacy, and I'll confess my family was one of them. I mean, my father's side of the family all comes from Mississippi and Memphis, Tennessee, and they all fought in the Confederacy. But you push them down, they're going to push back. And that's exactly what happened. And you gave them the opportunity to do that instead of giving time to heal those wounds. And I think Grant was right. He should have left the military in the South a little longer and let things simmer down.
What type of parallels do you see from that dispute and leading up to recent disputes within elections?
Well, one of the ironic things, everything I say, people can certainly disagree with. And the Chief Justice of the United States Supreme Court certainly disagreed with me, because after the Bush versus Gore thing, he wrote a little thin book on the Hayes-Tilden dispute. And it ends up, got resolved, and everybody lived happily ever after.
That's
like
right.
a fairy tale. I don't think that's necessarily true, but I don't purport to be the sole judge of all these things.
So John McMahon was also involved and was serving during the Belknap impeachment trial. The shenanigans going on there, the loss of Little Bighorn. Can you talk a little bit about that?
Yeah, he was the boy hero. He was in Congress, and it was the first big impeachment case before all the ones that we've had in recent years. But he's the guy in the House of Representatives that is the prosecutor of General Belknap, who was the Secretary of War in the Grant administration, and who was allegedly getting kickbacks from the Western trading posts. They'd send this money out to these Western trading posts, and he was filling his pockets with a good percentage of it. The impeachment trial lasted a number of weeks. You can go to the Dayton Law Library, and they've got the full transcript of the whole thing if you really want to bore yourself with reading it. But John McMahon was the prosecutor, and he was just lionized in the newspapers all over the country as being this brilliant prosecutor that was just destroying this Secretary of War, and he would have to. In fact, what happens is he is impeached at the end of the game, but before it gets to the end of the game, he resigns. So it's an empty chair. The other empty chair is the witness box, because one of the star witnesses in the impeachment trial, which was held in July of 1876, was a general with flowing mane of white hair from the Civil War and out the Wild West, who lost his life and his whole troops at the Battle of the Little Bighorn, which was held a week before the impeachment trial started. So General Custer did not show up for the impeachment trial and didn't fill the witness chair.
He wasn't present for that?
But again, there's two things, and those are both fairly early in McMahon's career, but they're two things that resonate still today. I mean, issues of impeachment are hot issues as we sit here. And the election issues and what do you do about the Electoral College as opposed to popular vote? Still live, hot issues with us.
And I can't.
So McMahon didn't solve it all.
I know, right?
He sure played with it.
And I can't tell when I see and read about the issues, whether it be impeachment and election issues today. I can't tell if it's refreshing that I also see it over 100 years ago, or if I'm depressed just because. Maybe it's like, well, made it through that, we'll make it through this too. I don't know.
Yeah, I think you should never get depressed over anything. That's a bad.
Right, absolutely.
Black clouds over your head don't help you at all.
It doesn't help.
You just got to do the best you can. It's like McMahon told to that young judge, my job was to do the best I could for my client. Your judge, that's the reason I never became a judge. That's a heavy responsibility that you have.
It's pretty heavy.
Yeah.
It is.
You need the whole Dayton Triangle team to pull you through.
Can I get a robe that's got a big triangle, just as a Dayton triangles? That'd be kind of cool.
And every judge ought to have a little sign that says, I'm doing the best I can.
I'm gonna put that right above my bench. It says, "Look, listen, I'm trying. I'm doing the best I can."
It's a tough job.
It is.
And I, being an old trial lawyer, I haven't had too many issues where I've had to be in a quasi-judicial capacity. And I'll never forget the first one I had. I looked in the mirror in the morning and got shaved and looked at my poor ugly face and said, well, here's my chance to show how objective and dispassionate I can really be when I'm called upon to act that way. Right. And about 3 words out of one lawyer's mouth, and I'm saying, I'm going to find a way to stick it to this guy. Yeah. Oh, well, everybody's got their own personality. We get to carry it around through life.
That's the part. That's the part about it. And that's, I've had the opportunity to serve and judge as judge for the past 4 years, and it's been fulfilling. It's been great. And one thing that makes it so great is the attorneys that appear in front of you. I mean, Dayton, I can say Montgomery County, Miami Valley as a whole, Gym City, whatever you want to call it. Like you said earlier, you fight hard for our clients, and when you win graciously. If you lose graciously. Typically, folks are going away satisfied at some point, but even in the end, you live to fight another day. And I don't know if you can say that for every jurisdiction. I mean, you hear from a lot of folks who say, I want a lawyer that's going to drive them into the ground. That's going to be a ball-busting judge or a ball-busting lawyer, and just going to, and it's sometimes that doesn't necessarily get the results that you want.
No, you build up for a storm.
And it seems like John McMahon had a sense of just the ability to be calm in any situation and to argue and fight for his client. Was respectful, got his point, was brief, wasn't over the top, and still got the job done. I found that was very fascinating.
Yeah, I had a partner who became a common pleas judge, and he was always had this rule that, there are 2 ways of saying no to somebody. You can say, Mr. So-and-so, the answer to your question is no. You say, no! And, there's lawyers that do it both ways.
Yeah, right.
But the effective ones are the ones that know how to do it in a professional manner.
And it goes the same way, when I read about John McMahon and how he conducted himself. Even as judge, there's been times where, you can have a defendant who may completely curse and yell at you in the courtroom, and you can go the same direction with him. Like, he can say, you know what, F you, judge. And I can say, well, go F you too. And then everything, just the temperature in the room just raises, and it's just kind of like, I remember I had some students when there was a defendant, and let's just say he was in the yellow instead of your blues. He had the yellow on. And as you can imagine, I was preparing for anything to happen, and he completely just went off, just went crazy. You got me effed up. And he just went nuts. And I kept myself together, and I told Mr. Such, you have a great day. We'll see you in a couple weeks. And I had some students in the background and from high school, and they came up and like, did you want to yell at him? And I say no, because again, the temperature is going to continue to rise, and it's just not going to be worth it. Why does everyone need to be at a level 12, And I've noticed that a lot of the attorneys who, if I rule against them, they take it and they say, okay, we'll move forward. And there's attorneys who, if you rule against them, they completely fly off the handles. And it's just quite interesting watching that dynamic.
Bob Brown, when he was a judge here on the common pleas bench, had one of those episodes where a client got sentenced or in front of him. And the client went off on him and called him every name in the book, including a whole lot of names that I don't think had ever gotten into a book. And had the same question afterwards, why didn't you do something about that? Cite him for contempt or put him in jail for contempt on top of his sentence? And he said, he's a human being.
Right.
And if I'd been in his shoes, I would have gotten what I just gave to him. I'd have felt the same way. I might not have said anything, but You can understand. You have to have empathy for everybody with whom you deal.
Yeah, knowing people is the best part. If you don't know people, you're not going to be a good attorney. You're not going to be a good judge. So, well, that's episode 3. We got to learn John McMahon and how he, I think still what his legacy we learned from today. And you can read more about John McMahon in your book that I still can't pronounce. I've been trying. Slough of History's Boot Soles.
Yeah.
Slough of History's Boot Soles.
It has nothing to do with SOULES.
Be sure.
I apologize for that book title. It's cost me a lot of money. I bet that could have been a bestseller.
It couldn't cost that much money. Well, in letters, did they pay? They charge you in letters?
No, but that book was for sale.
Be sure to subscribe where you get your podcasts. On the next podcast, Retrial Podcast, we're going to meet another lawyer, Dayton's lawyer, Herb Eikenberry, also known as the Ringmaster of Dayton. I can't wait. That's going to be a fun one, right?
If we can't get a little laughter going in that one, we're not doing our jobs.
Yeah, that'll be the last one then if that doesn't work. I don't know what to tell you, so thank you. This Dayton Bar Association and Dayton Bar Foundation project was funded by a grant from Dayton Legal Heritage Foundation of the Dayton Foundation, and also by a grant from Jack W. and Sally D. Eichelberger Foundation of the Dayton Foundation. Thank you for your support.
Throw another word in on top of the thanks to the foundations that have supported us here, and that is, they sometimes call lawyers barristers, they call them solicitors, so I'll jump into the role of solicitor and say, hey, if you'd like to support this stuff, the Dayton Foundation, all of these foundations would be only too happy to accept your gifts.
This is a 6-episode pilot podcast, and with your support, we can find funding for future episodes. Support us by subscribing, leaving a review, and comment.